Okay, so welcome everyone to the last but not least session of helping your parents move. Today, we are honored to have a very special guest. Lorenzo Bonera is a lawyer, real estate lawyer, amongst other things. And I've used Lorenzo's services many a time with my clients. He's very good at what he does and has lots of experience. He's with NBC Law Professional Corporation, and he is joining us today to talk to us about some things. So, as we've been talking about this whole last 6 sessions, all of the things that we as children and or adults who are moving have to deal with, and especially if we're helping our aging parents through this. Wills, probate, and estates are really, really important. And again, one of those things that we have to have a conversation with our parents about just so that we have a plan. So today, Lorenzo is going to be touching upon the importance of having an updated will. How many here have an updated will? Raise your hands.
How updated do you mean?
Well, you know, updated.
Like 20 years?
Yeah. And then ins and outs of joint tenancy and the right of survivorship, and then how probate affects the sale of a parent's home. So, Lorenzo, I'm gonna put it on to you for you to continue and give us all the information you know.
Thank you, Anna. Good afternoon, everyone. Anna and I think we're coming up on 3 years that we've been working together.
Yeah.
I have been working alongside her. It's been very pleasant, and I'm glad I've been helping your clients. So I'm grateful that you invited me here today. I am, like Anna said, I'm a real estate lawyer, but that's only part of my practice. Really, my practice spans over real estate, wills and estates, and corporate law. Our office is at the corner of Carling and Bronson, where when you're driving down, you're probably seeing the big the building with the big PWL sign on the last floor, where one of the offices in there. And the reason for me being here today is that I wanted to touch upon a couple of issues and talk about some of the questions that I most often get from clients that are either in the process of downsizing or from clients who are children of people that are downsizing or are executors of estates. They're managing an estate, they're administering the estate, and they need some guidance, especially with respect to the sale of real estate. So the first thing that perhaps it's often overlooked, and I'm gonna sound like you probably heard this so many times, but the how important it is to have an updated will and POAs. So at a very high level, the important thing to know is the will deals with how you want to manage your assets at the time of your passing. I always tell my clients, you're not really doing it for yourself. You're doing it for the people that you're leaving behind, because you'll be gone, you will not care, but you can actually save a lot of time and effort to your executor and to your beneficiaries. Whereas for the POA, POA is an acronym. It stands for power of attorney. It's a document, or actually 2 documents, that allow you to name someone or multiple people as people that can look after your care and your property in the event that you are still alive, but for some reason can't look after yourself. So think of the situation of a couple where, let's say, the husband starts suffering from dementia. Having a POA in which you name the wife as the person that is allowed to be dealing with the banks and making all the decisions can save them a lot of time in coming to see me and having find alternative ways to fix the situation. So very briefly, if I were to tell you what are the real advantages of having a will done, updated will done, and having POAs in place, either for yourself or for your parents, you just need to think of the following situation. If you don't have the will done when you pass, someone is going to have to step forward and apply with the court to be appointed as the executor of the estate. This is going to require a certain amount of work, mainly related to why it should be that person that's stepping forward and why a judge should grant that person the power to be dealing with the assets of the estate. If you do have a will done, you're taking all the guesswork, or I would say most of the guesswork out of it. You're clearly stating what is the roadmap. You're saying who you want to administer the estate and who should be getting your assets. You're going to probably help your children or who your beneficiaries are in avoiding unnecessary friction. With respect to the POA, it is true, and I often am told when meeting with clients, when I tell them, you should have your power of attorney done, I'm always told, well, look, what happens if I don't have one done? What are my alternatives? And I always say, you really have two alternative situations that you can deal with. If you have a let's suppose you have a parent that didn't do a POA, and all of a sudden you have to step in because, like I said, they have a medical condition that doesn't allow them to make decisions. They've lost capacity and they cannot make decisions for themselves anymore. You're going to have to, again, go through the court. You need to get what is called a guardianship order, which is a specific procedure provided under the Substitute Decisions Act. It requires filing medical evidence with the court and, again, proving or satisfying a judge that one, the person has become incapable, and two, that you, the applicant, are the best suited person to be appointed as the one that has the power to deal with all the assets. It can be done, but it takes more time, it takes more effort, and it costs more money. Whereas with a couple $100, you can have your POAs done and avoid all that grief. The other, I guess, self-help remedy that people use, or that some bankers suggest, is the one of putting your children as joint account holders, especially with your bank accounts. I'm not gonna say no like straight away. Yes, it's a way to deal with it, but it comes with certain risks. The first one, and I'm saying this when I'm looking at it from a perspective of a parent, is that if you put your child as the joint account holder on your checking account, you're opening the account to all the creditors that your child may have.
Right.
Okay, so that's a risk. This is not to say that anyone is going to come in and grab your money, but it is possible, right? Your child gets sued, gets in a car accident, gets sued, can't repay damages. They can go after the bank account that you own together with your child. And the other issue with the joint account is that in Ontario, at least, there is a presumption that if you put a child as the joint account holder on your bank account, that money, when you pass, is to be kept in trust for your estate. But there have been circumstances where the child doesn't really pay attention and willingly or unwillingly uses the money. And once that is done, all of a sudden, the estate litigation begins. The other siblings obviously take issue with the use of the funds. So while using a joint bank account holder can be a solution, you have to be careful in using it in the right circumstances. So speaking of joint bank accounts, there is another thing that you can have in joint names, and that is the real estate. And the most, I would say, most common example that you find is when spouses are owning property together. You come to see a lawyer like myself, you're buying a property, you put yourself and your spouse as the joint tenants on the property. that is a tool that can be used in several situations. So just to take a step back, we need to have clear what the benefits of the joint tenancies are. There are two common ways in which you can hold real estate in Ontario. You can own it as a joint tenant or as a tenant in common. The big difference is that if you own property as a joint tenant with someone else, when you die, that property is transferred automatically into the name of the surviving, let's suppose, spouse, instead of going through your estate. The benefit of that is that you don't have to pay probate tax on the value of that asset. So the typical example is a couple, one of the spouses passes away, they go see their lawyer, they register a survivorship application on title, they update the registry of the property to show that there's only one owner at this point, no tax is payable, perfect. You can see how this tool though could also be used in a different situation as an estate planning tool to avoid probate tax. So I had to give you another example, I have a case I'm currently dealing with where the father just passed away. The mother is left as the sole owner of the property, but she will likely not live far longer either. So in the scenario I'm dealing with, we have come up with a solution of transferring the property from the mother to the mother and the children together as joint tenants, so that when mom passes in a couple of years, or hopefully longer, the ownership will automatically pass to the children, and the children will not need to, one, pay the estate administration tax or probate fee, whatever it's referred to as, and possibly also not have to apply to the court to get the certificate of appointment of estate trustee altogether. So earlier I mentioned that when you transfer property to your children as a joint account, the property is considered or is presumed to be transferred in trust to the children. That rule applies for real estate as well. So when the mom transfers the title to the home to herself and the children are supposed to own it only for the benefit of all the estate of the mom. Again, similar risks need to be considered. So there is plenty of case law out there where the parent wants to be smart. They don't want to pay the probate tax to the Minister of Finance of Ontario. They transfer the property to only one of their children. That one child, when the parent passes, says, oh, but that was a gift. I own the property. It wasn't supposed to be for all my brothers and sisters as well. So in those situations, when I'm meeting with a client, I always insist and I make it very clear that it's very important to record what your intentions are. If it is true indeed that you want to make a gift of, let's say, your home to one of your children, we should put it in writing somewhere. Whereas if that's not the intention, the opposite intention should be recorded. And therefore, when the child is taking title with the mother, it should be acknowledged by both that that is a transfer made simply in trust. And then at the end, when the mom passes, the property is to be sold and all the proceeds to be split between all the beneficiaries.
Right.
Having said that, this is a perfectly legal estate planning tool. It is currently used. The government of Ontario is aware of it. They simply have decided not to plug the hole. And it may be that next year or in the next budget, they'll try to change it. But for now, it's still working.
Right. Any questions, guys, so far?
No, that's good. It's really clear.
Very clear.
Okay.
Great. I think there was also another thing I wanted to talk to you about. We've covered the joint tenancy, the use of wills. Oh yeah, this is more practical than anything, but where you are, and it gears mostly towards those people that are in charge of our executors. They're dealing with an estate and they have to sell real estate. They're working with Anna, and they say, okay, we have this property, we have to put it on the market. You already know, and I've already said that you need to go through in most cases, you need to go through the probate process, and you need to obtain from the court that famous certificate that tells the public, that tells third parties, look, I'm the person entitled to be selling these assets. You want to be careful when you're selling the property and setting the closing date, that you're setting a closing date that's far ahead enough that you give the time to the court to issue that certificate to you.
Right.
At the beginning of the pandemic, when the courts were shut down, at the Ottawa courthouse, it was taking 4 months to get a certificate of appointment of a state trustee. That caused a lot of trouble. A lot of deals had to be extended. And I'm saying this because with the extension of the deal, you as the executor, the person signing all the papers for the closing, are potentially exposing yourself to liability. If the deal gets extended and that third party that's buying the estate property incurs damages, you may get sued and you may have to defend in court against the claim for damages. So the practical solution to that when working with your realtor is always to say, okay, maybe let's just give a call to the lawyer and let's figure out where the courthouse is at in terms of processing times right now for certificates, so that you don't get stuck. You don't agree to sell the property in a month from now, and you don't have the paperwork to get it done by then.
Right. So pre-COVID, what was sort of the timeline to get probate stuff done?
Every courthouse is different. In Ottawa, you could get it turned around in a month.
Okay.
At the beginning of COVID, it became 4 months. Recently, the courts are moving everything online. So I have heard of a colleague in my office filing one 3 weeks ago, and she got it. She got the certificate in 2 weeks.
Okay.
So things are getting faster, but they're still working through the backlog.
Okay.
So that's something to keep in mind.
Okay.
I did one in L'Orignal last fall, and it took me 3 days to get the certificate. Clearly, they were not busy in L'Orignal then.
Wow. Yeah. Lorenzo, there's a question on the chat. What is the difference in amount that it costs to add someone's name as joint tenancy versus probate fees? Good question, Sharon.
Okay, so to add someone's name, that's actually an excellent question. You're looking at the cost, let's say the legal fees, which is generally around $500 plus the tax and the registration to the government. You have two more points to consider. The first one is there going to be any capital gain tax triggered by the transfer? If the property that you're dealing with is your parents' principal residence, likely you're exempted from capital gain, so you're okay on that end. The other tax you want to think about is the land transfer tax, because as you know, every time a transfer of real estate takes place in Ontario, land transfer tax is payable, except, and then you got to go through the exemptions. A transfer from a parent to a parent and their son is one of the exceptions. So long as I look at the file, we cover the bases, we say, okay, there's no tax payable, no LTT, no land transfer tax, no capital gains tax. There's only the registration fee of $77 and the legal cost. That's what you're looking at to put someone else in title. Whereas if you have to pay a state administration tax, the tax is it's a percentage of the value of the estate. So let's say the estate is worth $100,000 in total. That's suppose. The first 50,000 are tax-free. After the first $50,000, you start paying $15 for every $1,000 of value. And then after a certain amount, I think the tax gets higher. But that's something to consider. Like usually you may be incurring $2,000 to $6,000 or $7,000 in probate tax if you have to go through probate and real estate property is involved.
Mm-hmm. Okay, so a very good question, Sharon, and something
Yes.
to check in with your lawyer about. And if you don't have a lawyer and need some questions, Lorenzo is really great at getting back to people. So that's awesome. Okay.
Yeah, and well, I think I probably confused you enough for the day, but
No,
if
I've
you
got
have
a
any other question, I'm happy to answer.
I have a question.
Mm-hmm.
Our will is in North Bay, and we will be moving to Ottawa. Is it a good idea for us to make out a new will once we get in Ottawa? We just have one daughter, and they live in Ottawa.
Okay. Yes. So the change of location in and of itself is not of concern. You could simply have your North Bay will move to Ottawa, or either take it with you or bring it to a law firm and they put it in their vault. In terms of doing a new will, I think that the criteria is the following. You have to look at when's the last time that I did the will, and then say, since then, has anything in my life considerably changed? So does the will still reflect where my intentions are? Do I want to leave something to someone else at this point? Is the executor that I had named back then still suitable or still willing to act as my executor if I were to pass?
Okay. Thank you.
Yeah, I just redid mine as well with my ex not too long ago because we hadn't done ours in 15 years and things had changed. So it was a good exercise to go through and just to really rethink about, God forbid something should happen to us, are the executors that we had chosen still good? Are they still with us? Right? Because sometimes they've passed on if the will's really old. And so now really there is no executor. So very good process to do, not wait too long to do it and then to update it when it needs to be updated. I don't know, any other questions, guys, for Lorenzo at all?
No, I think that's pretty clear.
Okay, great. And anything else you want to add, Lorenzo, to the call today? Anything that's kind of running across your desk more often now than not, or anything COVID related that we need to sort of keep in mind moving forward?
COVID related, the only thing is the government last year introduced legislation that now allows you to sign your will remotely.
Okay.
I think they're looking at making that permanent. I have done it a couple of times, especially in situations where the testator, the person making the will, wants no contact whatsoever, doesn't want to move out of the house, obviously for health reasons.
Right.
I am not a big fan, I'll be honest. I think there's a lot of risk with remote wills. It's very hard to tell who else is in the room when the client is signing the will, but it's an option that's out there and it's available if necessary.
Okay, that's good to know. Okay.
That's interesting.
Yeah. Okay. Wonderful. So thanks everyone for coming today. I will send this out again, this recording, and if you want to share it with anyone, you're more than welcome to. I have put Lorenzo's contact information in the chat if anyone wants to reach out to him with some questions, or you can reach out to me and I'll put you in touch with him. Lorenzo, thank you so much for your time today. I know you're a busy guy. And
thank you very much to you.
I will be reaching out to everyone in the next couple of days just to get some feedback about the program in general. If you enjoyed it, was there anything that was missing that you wished we had talked about? Because I do want to run this program again. I want to do it maybe a couple of times a year for different people, from the perspective of the children to doing another session mostly for sort of the seniors. So Any feedback you can give me would be greatly appreciated. And I wish you all a very wonderful day.
Thank you.
For your time, and we'll be talking soon.
Thank you.
Thank you.
Enjoy the
Lorenzo.
sunshine, everyone. Bye-bye.
Thank you.
You too.
Bye.
Stay safe.
We have to stay.